Good evening, everybody. This is my presentation on the Fourth Amendment for our CRJ 306 Criminal Law and Procedure class. The first question is, what is the Fourth Amendment? The Fourth Amendment is defined in the Constitution as something that provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things being seized. And not such legal jargon. The Fourth Amendment ensures that the government may not illegally search and or seize a person or property without probable cause that can be proven in court. Requirements of the Fourth Amendment. Probable cause is a constitutional requirement for the search and seizure under the Fourth Amendment. It's clearly, well, that term is used in the Fourth Amendment and defined in multiple court cases throughout United States history. Reasonable suspicion may be used to conduct limited searches as well. Probable cause and reasonable suspicion are initially determined by law enforcement and later confirmed by the judicial system in court cases. And to clarify, the Fourth Amendment may not be changed or altered by any local or state laws. What is a warrant? According to Cornell law, a warrant is a writ permitting or directing someone to take some action. Frequently, the term refers to a writ from a judge permitting law enforcement personnel to take some action, such as make an arrest, search a location, or seize some piece of property. A warrant should be reasonable and used with reasonable force. For example, a warrant for speeding tickets should not be treated the same as a warrant for an aggravated crime. Again, reasonable force must be used. There are exceptions to the Fourth Amendment. Exceptions include consensual searches, brief investigatory stops, and searches of items in plain view. Courts again will determine the constitutional legality of the search and seizure. The exclusionary rule is used. It prevents the government from using evidence gathered in violation of the United States Constitution, specifically the Fourth Amendment. Illegally obtained evidence may not be used in court to prove guilt. This puts added pressure on law enforcement to gather evidence the correct way. Exceptions to the exclusionary rule are good faith, independent source, inevitable discovery doctrine, attenuation doctrine, evidence admissible for impeachment, and qualified immunity. If you feel like your Fourth Amendment right has been infringed upon, you can use a motion to suppress. A motion to suppress exists when a defendant attempts to prove that evidence against him or her was illegally obtained and therefore judged constitutionally legal or illegal. A motion to suppress may result in evidence being removed from consideration or a case being dismissed completely. So again, it puts a lot of pressure on law enforcement to ensure that they're obtaining evidence legally. A lot of my references are from Cornell, but that concludes my presentation on the Fourth Amendment.